Good afternoon. Another quick lunch. But if given the choice between great panels and long lunches, I hope you understand we're choosing for the first and not the second. So this panel is entitled Innovative Practices in Sentencing. Let me introduce our moderator, who will then introduce our panel. Hanna Liebman Dershowitz is the Director of Policy and Legal Affairs at the Center for Justice and Human Dignity, a former journalist, a lawyer. Hanna has served in the criminal justice reform space for over 20 years, including with the Innocence Project, the ACLU of Southern California, the Aleph Institute, and New Yorkers United for Justice, among others. I'd be remiss if I did not give Hanna a big, well-deserved shout out for the tremendous work she has done over the last year or more, along with her colleagues, helping to conceive, organize, prepare, and produce for you this Rewriting the Sentence 2 Summit of 2023. So thank you.
Thank you.
While I'm giving accolades, let me just give a brief but well-deserved shout out to Yossi Bryski, the Director of the Alternative Sentencing Division, of the Aleph Institute, is on this panel, and with whom I have worked extensively over the course of the last 2 years. He's just a terrific advocate on the ground, in the trenches, in dozens of cases over the years for alternatives to incarceration, in appropriate cases where remorse and redemption and repair and restitution and rehabilitation provide a better pathway to justice than prison. So keep up the great work.
Thank you, Alan. Can you all hear me? Good afternoon, and welcome to the Innovative Practices in Sentencing discussion. I am Hanna Liebman Dershowitz. You've already just heard who I am. We've talked a lot over the past 2 days about ways to bring programs in the courts and supports in the community to scale so as to improve outcomes across various dimensions of our system. This panel is a reminder that one person's choices and decision-making is often the difference in these outcomes. This summit is as much about individual decisions as anything else. Decisions to think of people as human and individuals, and decisions to be part of a system that moves toward more responsiveness to the needs of all parties when resolving breaches of societal rules. The first panel yesterday, you might recall, talked about the formal programs in place to divert people from incarceration and into more productive interventions, specialty courts, diversion by law enforcement, and the like. This panel is about the people who make the decisions. How do they innovate on their own? Think about the ideas you've heard about yesterday and today. Is there maybe one idea that you could bring into your practice on a regular basis, maybe even more than one? Bigger toolbox? Maybe you're someone who will burgeon into a leader in this field, a giant like Judge Jack Weinstein, who we were able to pay a tribute to last night, or Judge Carlton Reeves, who just gave a tremendous leadership speech. Maybe you'll be on the stage at the next summit talking about your personal journey toward a more compassionate and responsive posture toward people who come before you every day, a transformation of the likes that we heard from Steve Toppins yesterday. But if you change even one practice or think longer before imposing a sentence of incarceration, we will have met our chief objective, to raise awareness and use of alternatives to incarceration, both at the individual stakeholder level and across the system as a whole. In the next hour or so, you will hear from an amazing array of experts, such as Judge Mark Bennett, way down at the end there, a former Iowa Federal District Court judge who has personally visited more than 400 people that he has sentenced to incarceration. A practice very seldom undertaken by judges, as many of you know, and he's adopted various other humanizing practices when he was practicing in his courtroom. You will also hear from Judge Karen Friedman, Director of Criminal Justice, Innovation, Development, and Engagement at the DOJ's Bureau of Justice Assistance, also a former Baltimore judge who will share practices she implemented in her court. Judge Ginger Lerner Wren, the pioneer of America's first problem-solving and diversionary mental health court, We'll talk about the immense challenge posed by the large number of people with serious mental illnesses and co-occurring disorders cycling through our criminal courts, and about how to infuse dignity in every corner of a courtroom. Keto Bess, Chief U.S. Probation Officer for the District of Minnesota, will explain how innovative practices in probation can contribute to smoothing reentry and helping people succeed. And Yossi Bryski will talk about his alternative sentencing work for Aleph and explain how critical it is for individuals impacted by criminal legal system involvement to have people who really know them and can fully humanize them for judges who have little opportunity to interact with them fully. I'm going to turn it over to each panelist to make a brief opening statement, and then about 5 minutes each. Then we'll have some discussion across the panel, and I'll stop early for audience questions, so keep them in mind as we go through. I would like to start with Judge Friedman. You were a state court trial judge for more than 2 decades and headed Baltimore's drug treatment court. You became known for applying that broader tool set we talked about of the problem-solving courts to your regular criminal dockets. What inspired that, and what specific practices can the judges in our audience use in their courtrooms?
Thank you, and good afternoon, everyone. I'm so honored to be here and be on this esteemed panel. I'm going to start off by saying that I am not here on behalf of DOJ, and I'm here speaking as a former judge in Baltimore and a state court judge. You've heard from a lot of federal judges. There are not as many state court judges here, and that's a very, very different type of docket. The way it worked in Baltimore was I was the Baltimore drug treatment court judge for the highest trial court, but that was only about 2 days a week. The rest of the week I had a regular criminal docket. And in Baltimore, at least in Maryland, the judges are given maximum sentences, but we are not given minimums. So we have a lot of flexibility in our sentencing, which I know a lot of the district and the federal judges here are probably very jealous about because we have a certain level of flexibility. So, you know, I became the drug treatment court judge and was trained with the training that all drug treatment court judges receive. And then I would go to my regular criminal docket, and the people there had the exact same problems that I was seeing in my specialty court docket. And I just couldn't understand why we were treating these 2 dockets differently and why I was being trained in one way and the judges that only did regular criminal dockets was not receiving the same training. So every docket that we have, there are underlying conditions that have brought these individuals into the criminal justice system, whether it's addiction, whether it's mental health, whether it's homelessness, lack of education, lack of a job. And there were some people who qualified for specialty courts, and there were some people that didn't. Either the crime that was that particular crime was not eligible. Perhaps there was a conviction on their record in the past that made them ineligible. There are some statutory restrictions to who can go into a diversion court, and frankly, a lot of those rules and regulations adversely affect Black and brown people, which is a completely different topic, but a very important topic. But at the end of the day, the life situations of the people that were going into the drug treatment court versus the people that were going onto my regular criminal docket were nearly identical. And, you know, so I really began to shape my regular criminal docket in the exact same way as I did my treatment court docket, except without all the support, right? The treatment dockets, you have a case managers, you have probation officers that are specifically trained to be on that docket, you have a prosecutor that's very treatment-minded, et cetera. And you have the community resources. So what I started doing was going out into the community myself and finding the resources in the community, the partners, the people who are doing good drug rehabilitation in the community, the people who are providing mental health services in the community, the people who are doing vocational training and educational training in the community, and inviting them into my court and into my docket. And I would basically fill up my jury box with representatives of these different agencies. And as individuals would approach the bench, I would do another thing that I did on my specialty docket. I spoke to them. I learned who they were. I asked questions. I used the motivational interviewing skills that I got taught at when I was doing the specialty docket in that regular docket to really begin to know the individuals who came in front of me and thereby be able to develop a relationship with them. And once I learned what their issues were, I would partner them with community resources that were sitting right there. Oh, you're suffering with substance use? This organization is going to take you to the jury room right now, and we're going to do an assessment right now. Because we know for this population of people, that one extra step of, here's a phone number, call them tomorrow, make an appointment, that's one too many steps. If they were able to organize their lives that well, they probably wouldn't be in front of me that day, right? So as many hurdles as we could eliminate to getting those services, the better off those individuals are going to be. And I'm at my 5 minutes, so I don't want to take any more time, and we'll have follow-up. But for me, it was really about building those relationships, and I'll explain a little bit further on in the session how I actively built the relationships. But to me, the greatest thing a defendant in front of me could say is, Judge, you're going to be so disappointed. And the reason why those were the greatest words I ever heard was because if I don't care about you, you can't disappoint me, right? A stranger can't disappoint you because they're not invested in you. The fact that an individual was able to say to me, you're going to be so disappointed, means he truly understood that I was invested in his success. And that's a beautiful thing.
That's a great place to end it. Thank you so much. Judge Bennett, I'd like to turn next to you. Can you share how your practices when you were on the bench humanized your courtroom and the people who came before you, and also about how visiting prisons and taking an interest in each individual you sentenced made an impact on your judicial philosophy?
Sure, thank you very much. I'm just so honored to be here. I'm Mark Bennett, formerly known as Judge Mark Bennett. That's a joke. I retired 4 years ago. I was doing a sentencing. I had sentenced over 4,000 people to federal prison, over 1,500 mandatory minimums. And I had taken senior status, and I was doing a sentencing. My law clerk said at the end, when I was supposed to impose the sentence, there was dead silence for 7 to 8 minutes because it was one of the many unjust sentences that I was forced to impose a mandatory minimum. And I started crying, and I imposed the sentence, and I walked off the bench, and I told my staff, I'm done. I don't have another sentencing left in me, and I retired. I started visiting inmates early in my career because I just thought it was important to understand their environment. And I started my career when I graduated from law school. Nobody wanted to hire me. So I got a law enforcement assistance administration grant to do prisoner rights work at a maximum security prison in Iowa, and that's how I got my start. And I was always intrigued and horrified by visiting federal prisons. So I started visiting the inmates that I had sentenced. I started with I got a list from probation. I started trying to have the maximum impact on me by visiting the prisons where I had the most inmates. I was the #1 populator at a federal prison in South Dakota, in Yankton, South Dakota. Over 200 of the 800 inmates I had sentenced there. And so it had a profound impact on me. But other things had a profound impact on my sentencing. When I was very young, I read a book about Thomas Edison. I don't remember anything about the book except the quote, "There's a better way to do everything, go find it." And so that was the kind of my mantra. I also read several books about Martin Luther King, and the quote that left an indelible impression on me was, "The arc of the moral universe is long, but it bends towards justice." And when I was a trial lawyer before I became a federal judge and a criminal defense lawyer, I had that tagline on my letterhead. And I had that tagline on my letterhead as a judge and on my email address. Except when I became a judge, I added the following sentence, "But it doesn't bend on its own." And then the third thing was when I was in first grade, my first grade teacher was brutally criticizing my best friend, who was very slow, wound up in special ed. And she grabbed me by, I stood up in my chair and I said, "Stop it." She grabbed me by the ear and marched me down to the principal's office, where I was sobbing, and my dad eventually came and got me. The principal said he should take me home, he could take me home. And my dad put his arm around me and he said, "I'm incredibly proud of you because you may never get a second chance to stand up for an injustice." So those three things have shaped my whole career. Visiting inmates taught me something I knew intuitively, but I didn't understand at an emotional level, and that was that these incredibly draconian sentences that the guidelines and the mandatory mandatory minimums required were draconianly harsh. And if I had $1 for every inmate who told me, "You know, I finally got it after 2 to 3 years," that was kind of the mantra that I heard from the inmates that I talked to. And I talked to several inmates that I gave mandatory life sentences to. So that obviously shaped my judicial philosophy. So here's some of the things I did. I reduced every drug guideline sentence automatically by 1/3 across the board. Once in 2005, when the Supreme Court ruled, we started getting some discretion. Then I went up or down based on the sentencing factors that others have discussed. And then with regard to crack cocaine, which bothered me incredibly, my mom died when I was very young. I came home and found her dead in the kitchen from elementary school. And I was raised by an African-American nanny. And so this 100-to-1 crack powder cocaine ratio was astounding to me. So once we got a little bit of discretion, I reduced it to 20-to-1. The Eighth Circuit reversed me in an in-bank decision, and then Mark Osler, who's in the room, filed a cert petition to the United States Supreme Court. Supreme Court reversed the Eighth Circuit, which they frequently did in my sentencing decisions. And the Eighth Circuit had a very bad betting average. And then the day Spears, United States versus Spears came down, I then went to a 1-to-1 ratio. First judge in the country to do that. Then when the Fair Sentencing Act came into play and Congress came up with this political compromise of 18-to-1, I kind of assumed I was going to have to follow it. But I had a long session with my brilliant law clerks, and we decided that I could still use the 1-to-1, and I did that up until the day I retired. Bernice Donald, I think she's in the room downstairs, but one of the highlights of my personal part of my professional career was becoming super close with Bernice Donald, and we traipsed all over the country teaching judges and lawyers about implicit bias. So when I was a relatively new judge, somebody got the great idea that we should have a photo of the defendants on the front page of the pre-sentence report. That sounded like a great idea, because in our district, we had such a heavy criminal caseload. We were usually 6th in the nation of the 94 districts. That magistrate judges took all our guilty pleas. So unless they did our suppression motions, so unless we had a trial, which I had over 250 jury trials, 60% of the defendants I tried in the Northern District were persons of color. The district was about 5%. And so once I started getting involved in implicit bias, became the first judge in the country to give an implicit bias jury instruction in civil and criminal cases, and I learned how to talk to jurors about implicit bias. I quickly figured out that that picture on the pre-sentence report, what cognitive psychologists would say was a primed our implicit biases. And interestingly enough, judges have greater implicit biases when it comes to race than members of the general public. And how do I know that? Because I did an empirical study and published it in a law review that established that. And so I took the pictures off the pre-sentence report. I also was really curious about why probation officers were making sentencing recommendations to us. That never made any sense to me. The other judge was concerned when I said I want to stop doing that they would be offended. So I said, I don't think so. So I did a random survey of the probation officers, and they said, we've never understood why we make a sentencing recommendation. We'd be thrilled not to make it. And so we stopped taking recommendations from the probation officers because I had no idea what their implicit biases were. And then I instructed the probation officers in the pre-sentence report at the end to have a bullet point listing of all of the mitigating factors under 3553A, because with all due respect to the defense lawyers, and I was one in my prior life, they didn't do a very good job of arguing mitigating factors. And I wanted to make sure I never missed one. So we did that. And then I got a book about, back then there were 118 federal prisons, and I studied all of the programs at each one of the federal prisons because they're very different. And so I would try to match an offender with programs based on what I learned in their pre-sentence report. Now, sometimes they didn't want that because they wanted to be closer to home, but I'll give you one example. I was sentencing a young black man who had worked in the fast food industry, and he wanted to be close to home, and I said, well, this was in the course of the sentencing, because I always asked him, where do you want to go? I'll make a recommendation to the Bureau of Prisons. They'll probably ignore it, but they may not. And he named some place, and I said, well, I've got an idea. If you go to a federal prison in Wisconsin, they have an incredible culinary program, and they place their people mostly in restaurants in Chicago. We're talking about high-end restaurants. And I said, what do you think about becoming a chef at a high-end restaurant in Chicago? And his eyes lit up. So he agreed to go a little bit farther from home. Now, their culinary institute was so great that when I visited there, they had a cinnamon roll for me when I met with the warden. Now, my wife has a master's degree in food science and was a food editor at Better Homes and Gardens, and I said, warden, would you give me one extra one that I could take home so my wife can deconstruct it? And I can eat these for the rest of my life. And so the biggest problem, and then I would meet with all of the offenders that came out every month into our halfway house in Sioux City, and I would meet and have lunch with them and tell them about what the expectations were on supervised release, because I didn't want them to go back. So that was a good program. Then along with probation, who took the laboring oar, we created job fairs so that we could match offenders with business people. Sioux City was a small community, 80,000. I knew most of the major employers, the owners of the company, most of whom had a no felon hiring policy. So I went to them and I said, you know, there's a huge labor shortage. These are going to be the best workers you've ever had. Give it a try. If it doesn't work after a year, go back. And so we were able to get people hired.
Thank you, Your Honor. Do you mind if I move? Oh, you go ahead. You
Can I
can do
just
one
end
more.
with one thing?
Sure.
One of the things I'm most proud of is in every sentencing I had, except in 2 death penalty cases, after I sentenced a defendant, whether I gave a downward variance, which I did 80% of the time, or an upward variance, I got off the bench and I walked over to the defendant and I shook hands with the defendant. The U.S. Marshals hated that I did that, but it was very important to me that the offender heard words of encouragement from me because I was the last person in the free world that they saw.
Thank you so much, Your Honor. That was really incredibly moving. Judge Lerner, Wren, I'm going to turn to you next. I learned from reading your beautifully written book, A Court of Refuge, Stories from the Bench of America's First Mental Health Court, that you consider dignity the centerpiece of court process. Can you explain what that means in legal terms and how dignity is manifested in your courtroom? Also, I think this audience would be very interested in the concept of therapeutic jurisprudence, if you don't mind addressing that as well. Thanks.
Thank you so much. And first of all, it's such an honor to be here and to see old friends, new friends. And I remember being a young law student, and I just got my first break in working in public interest. I was hired to be the public guardian for the 17th Judicial Circuit of Florida, which is Broward County, and I think most people know where Broward County, Florida is. I sit in Fort Lauderdale, and we have a very large county, about 2 million people. The state of Florida, by the way, is the 3rd largest state in the United States. We have very large pockets of poverty, and we are one of only 10 states without Medicaid expansion. And so our state is always in a crisis dynamic and always at the bottom of the rung, if you will, for mental health funding. It's really very saddening. And when I was a public guardian, I remember, and I think everybody knows what public guardianship is, but it was an office at the time. It was piloted under the probate court, and this was for indigent adults who had been deemed incapacitated by the probate court, but they had no family members to act as their legal guardians, and so it would be my responsibility to take care of their health, their safety, their welfare, make all medical decisions, even death arrangements. I was also the director of a relatively small office, 3 amazing social workers, yay, and they were fabulous, and I even took my own caseload of people so I could expand the service model. It was an extraordinary job, and I just loved it so much because it really put me right in the heart of the community, and I love collaborating, and I just love my community so much. And this was a job where you really needed to know everything. It was so interdisciplinary. You needed to know disability rights. You needed to know elder neglect and abuse. You needed to know about the ADA. You just needed to know all about guardianship and you name it. You just needed to know it. To make a long story short, in terms of the mental health court, I don't know, when I graduated from law school, I'll tell you the year I'm not that proud of. It was 1983. Nova Southeastern University Law School. At the time, it was called Nova Law Center. And I don't remember really taking any courses in mental health or disability law. And yet, I went to a conference in one of these really beautiful grand ballrooms, and I heard for the first time one of the experts talk about the criminalization of persons with, serious mental illnesses. And I had this really intense reaction. I just never heard of this. It was just never taught where I was at the time. And I just couldn't believe it. I have to tell you, I started, sweating. I think it almost looked like the walls were moving. I said, well, you mean people that are sick are in prison because of an illness? I just couldn't fathom it. And I remember saying to myself privately, if there's anything I could ever do, to help these people, I would. And sure enough, this journey, I think ever since that event, I went to a conference on therapeutic jurisprudence, and I got to hear extraordinary scholars speak. Professor Michael Perlin from New York Law School, that most of you probably know very, very well, and Professors David Wexler and the amazing Bruce Winnick from the University of Miami talk about that how can we, as judges and legal actors and probation officers, how can we humanize court process in order that we could act as therapeutic agents? Their scholarship was such that they started out reading, these opinions that would come from involuntary civil commitment hearings. And I guess the scholars do, they analyzed the case law and they would have these discussions, and their discussions focused on the fact that you just didn't hear the voices of individuals who were being subject to the petition for involuntary civil commitment. These orders were written in a way where there was no real balance. Their voices were never heard, and they were talking about, well, how anti-therapeutic could that hearing have been? And if a court hearing could be anti-therapeutic, their concept and their thoughts were, well, what can we do as judges? What can we do as lawyers? What can we do then, knowing that whatever's happening in a courtroom, that there's invisible, psychological forces at play based on how we act, based on what we say, and whether or not we even give voice to those that are in front of us, and how do we promote the perception of fairness in a court process? And they came up with this absolutely beautiful concept and science of therapeutic jurisprudence. And what does it really mean? It really talks more about how could we, really convert a process of a court experience from an anti-therapeutic one to a therapeutic one. And in that regard, social emotive skills, active listening, kindness, compassion, giving voice to defendants, allowing for storytelling, validation, coming from strengths, all of these aspects began to really take shape. The problem-solving court movement, we know, again, ironically, maybe I always said out of desperation comes innovation. The state of Florida, right? Miami-Dade, Janet Reno was the district attorney for Miami-Dade for the first drug court that was ever developed. And, she watched, and I read every single speech. And if you haven't done it, it's really something to do. To go back and read the speeches of Janet Reno as she was the assistant district attorney for Miami-Dade County during the, which was the epicenter of the cocaine epidemic. And we all know about Miami Vice and all of that. And, she just kept saying, we can't build our way out of this. We cannot build enough prisons in order to, get us out of this. There was no treatment in prison, and she was just watching this conveyor belt of individuals being arrested for drug possession. The drug court did, in fact, apply the science of therapeutic jurisprudence and concept of therapeutic jurisprudence so that judges could be empowered. Judges now can be empowered to treat people as individuals, correct? And to be able to welcome them, become cheerleaders, really, recovery coaches. We're able to step out of our traditional role in terms of problem solving and getting to the root cause and really understanding trauma and turning a courtroom into a classroom. When I came to the bench, I came with a strange trajectory. I was hired. I'm probably the only judge in the United States, I say it with some pride, that spent about a year and a half in a psychiatric institution. And I did that because I was asked from my role as public guardian to come on board to what is now known as Florida Disability Rights, but to come on board and serve as part of the plaintiff's team in the federal class action known as Sanborn versus Childs. Lawton Childs was our governor at the time. Our state hospital it was a regional state hospital located in Broward County, but served literally almost the bottom half of the state of Florida. I lived at that psychiatric hospital, which was extremely traumatic. There was no real treatment going on. It was a warehouse. It was a snake pit. And my journey there really led me to understand that we have got to do something to invest in our community-based system of care. And that lawsuit was really designed not so much to improve the conditions of that institution, but to build the capacity of our systems of care in the state of Florida. From that lawsuit, I decided to run for judge, but I was trained by a very immensely expert plaintiff's team as I ran for judge with adorable Ice Spice gingerbread cookies. My circuit on the criminal justice side had identified serious problems, and this year was now in the early 90s. In the early 90s, what were they seeing? What every jail was seeing. What every jail was seeing with the drawdown and closures of the statewide network of psychiatric state hospitals. Individuals now having nowhere to go with the failed policy of deinstitutionalization and really just flowing into jails now, serving as de facto psychiatric hospitals. So the overrepresentation of individuals being arrested with mental illnesses, co-occurring disorders, and other kind of neurocognitive disorders, with judges and lawyers not knowing what to do. These people were either getting trapped in our local jail, or they were spinning in and out like a revolving door, out to the streets, out to the hospitals, back into jail without end. A task force formed, two different parallel systems, substance use and behavioral health, for the first time ever came together, met for several years, could not find consensus on what to do about the overrepresentation of individuals in our jail system, but it really was the high-profile case of Aaron Wynn, which I'll talk about, I'm sure, as we continue upstream, that led to the creation of America's first mental health court, and he wasn't even mentally ill. He had a brain, it's true, the irony, the unlikely savior of a new system of justice coined by Frontline and PBS. He suffered a very serious motorcycle accident as he was preparing to go to college. He suffered from very severe brain trauma, ultimately ended up in a forensic hospital in the northern part of Florida, spent 2.5 years in solitary confinement in 4- and 5-point restraints. That is why, as we move forward, I want you to understand why America's first mental health court was, and will always be deemed a human rights strategy. Thank you.
Thank you so much, Judge Lerner. We all have our weekend reading. Janet Reno. Chief Bess, you lead U.S. probation in the District of Minnesota. Please share some of the impressive lengths your office goes to help people succeed in the community, like holding job fairs, the same thing that Judge Bennett talked about earlier, bullet pointing the mitigating factors and other types of things. And also, can you speak a little bit to the role of probation in ensuring sentences are tailored to those individual needs?
All right. Good afternoon. First off, I want to thank the Center for inviting me and appreciate for being here. Let me go ahead and go straight into sharing my thoughts. I want to pick up where Judge Bennett left off, though, with respect to the 3553 factors in the PSR. You know, I recall sometime in 2007, 2008, when I attended a Sentencing Commission's conference in Orlando, and I never forget a probation officer stood up during the question and answer period, and the panel was present. I think Judge Gertner was there, and there was another district judge there. And the officer stood up and asked the question of why is it that we as U.S. probation and pretrial services officers have to do the work of defense counsel with respect to identifying those 3553 factors on their behalf. And, you know, I have to tell you, when that happened, I put my head down and I said, please don't let that be anybody from the Southern District of Iowa at the time when I was there, you know, because I couldn't believe the question was asked. You know, I remember when Gall was decided, and I had the wonderful opportunity to work with Judge Robert Pratt, who was my chief judge at the time in Southern Iowa. But when Gall was decided, at the time I was in Southern District of Florida, and I was elated over having the opportunity to recommend a non-guideline sentence. And I remember there was 2 instances where, as the author of the pre-sentence investigation report, you know, I took the liberty and I literally, on 2 separate occasions, 2 different judges, one criminal defendant was pled guilty and another criminal defendant was found guilty. But in both of those instances, I recommended a non-incarcerated sanction, which was accepted by both judges. And to me, you know, that was one of the many highlights, which, you know, I wish I could go back to that young lady and say, this is why we should, you know, be doing this. As the U.S. probation and pretrial service officers, you know, we interview these folks on a day in, day out. We are that independent fact finder. We are what I call the author of what we're writing is their autobiography. Yes, it's a unique autobiography where we get to really highlight a lot of things about the criminal defendant that is before the court. But we also take that time to think outside the box and examine those factors that exist in that social history section, in the criminal history section, because there are some motivating factors with respect to, you know, substance abuse, mental health, whatever, that may have impacted why the person did what they did. And we have the opportunity to bring those things to light on behalf of the criminal defendant, on behalf of the judge, so that the judge can be able to consider those things. So as far as I was concerned, you know, I said, you know what, this is an obligation that we have as U.S. probation and pretrial service officers, as the neutral party, to be able to bring those things to the court for the court consideration. And we don't have to wait until defense counsel bring those things up. In fact, we should be consulting with defense counsels during the process to be able to verify the information as much as possible. I understand medical records sometimes, for example, we don't always get, but you know what? ask defense counsels as to whether or not do they have that information, take the information, look at the information, and be able to examine it and how it aligns with 3553. So in Minnesota, I recall, and I did the same thing in Southern Iowa. I did the same thing when I was chief in Eastern Louisiana, New Orleans. And, I said, here's what we're going to do. Instead of identifying the 3553 factors in that super secret recommendation page that defense counsels never get to see because it goes directly to the court, one of the things that I said was, look, I think one, when I started reviewing a PSR just by chance, and I said, hey, how come we have 4A1.3 factors, underrepresentation in the PSR, but then there's a lot of, factors here that can resemble reflect a possible variance, downward or upward. In this case, it was downward, but it wasn't in the PSR. They said, well, but it's in the recommendation page. I said, okay, well, but the defense counsel doesn't know that, so because they don't get to see it. So as a result, I called up my judge, and my judge basically said, well, Keto, that's been your office stance. I said, okay, well, since I just got here, I can go ahead and change that stance then. So, what I did at that point was, I made a standing rule, basically reinforcing what our Guide to Judiciary Policy and Procedures already says, and that is that our pre-sentence reports does have a section that talks about variances and departures, and Judge Bennett talked about bullet pointing them, and that's fine. I asked my officers to draw an analysis, identify the 3553 factors in the rules of criminal procedure, and then go back and make the analysis by looking at all of the information that you have in the PSR. And I love what Judge Nancy Gertner said back in 2007 or 8 at the Sentencing Commission, tell a story. And that's what I asked officers to do today. Tell the story. How is it that those 3553 factors align with the information that you have now collected and actually verified in the pre-sentence report to be able to tell the story so that the judge can actually consider when we're talking about making recommendations to the court for a departures, variance, or what that ultimate sentence is going to be. To me, that is what the role of the U.S. Probation Pretrial Service Office is, especially when it comes to the issue of making a sentencing recommendation to the court. That's how we get there. We have to verify the information. We have to, yes, I understand departures. Sometimes the law may dictate, case law may say, no, you can't depart based on this, and that's fine. But that doesn't mean that you can't use the same thing that you ordinarily would approach the court for a departure to also approach the court for a potential variance and then draw your analysis. So while we don't bullet point them, and I know a few districts bullet point, but I ask that we make an analysis. Tell the story and outline how you get to the conclusion. Real quick with respect to, once the person is sentenced, how we tend to handle things. I love what Judge Friedman was talking about, basically what she was talking about in terms of how she structured her and handled and managed her docket to include all of these representatives to provide those programs and services. I will be the first to say, whether it's a job fair, whatever program that we're trying to do, I think the first thing any chief probation officer needs to do is make sure that they have an organizational structure that is conducive to be able to provide specialized programs and services. Otherwise, you just may have a program that lasts for a season, and then it's here today and it's gone tomorrow. If you change the structure and you have a solid structure in place, then you give your program a chance to last a lifetime. And that's what I'm looking at doing. Dr. King once said that life's most persistent and urgent question is, what are you doing for others? And then I tend to follow President Abraham Lincoln, who also says about the legitimate object of government. And I do believe that when we have people who are under supervision that is coming to the U.S. Probation and Pretrial Services Office, it is like a hospital. We are there to help them. They are looking for a healing, and it is our obligation to make sure that we do as much as we can do. So what we have done, again, in terms of that structure, I have hired a community intervention administrator, someone who does not carry an active caseload, supervising individuals, but their caseload is managing the programs programs and services and bringing those programs and services to the organization to be able to implement. We also created, in terms of that structure, we gutted one of our old, since we try to be paperless, so we gutted our file room and we created a workforce development center in Minneapolis. It's a large room with 9 computer centers there where people can be able to come into the office, look for jobs, but not only that, because we know they can look for jobs on their phone now, but conduct workforce readiness programming. We've had 2 promotional opportunities for U.S. probation officers as part of our workforce development and reentry court initiatives, where they partner with the state Minnesota Career Force to assist with job searches and other career development opportunities. They also have assisted, I was at home one time and I saw on the news that they had a local trucking company that was offering CDL classes. So we ended up using Second Chance funds, got in contact with that organization, and literally provided, and in fact, I learned today 2 more graduates with their CDL Class A license through our Second Chance Fund, so we started that. Also, I had my chief judge challenged me on this, former Chief Judge John Thunheim, and I love him to death for this because I wouldn't have thought about it. But one of the things that we have started doing is we partner with the League of Women Voters because, again, we can talk about all the programs, but persons under supervision need to have a voice in the voting and in the democratic process. So one of the things that we've done is in June, the Minnesota state, they changed the laws allowing persons under supervision to vote while they're under supervision. Unless, if they're in custody, they can't vote. But if they're under supervision, the law has changed June of this year that they are allowed to vote. So we can't register them. So as a result, we partnered with the League of Women Voters, invited them to come to our courthouse, and we invited throughout the entire state anyone who's on any person under supervision. We basically notified them of this effort that we were making, this voter registration drive, and we had League of Women Voters come in and register folks to vote. And it definitely made headline news throughout the state of Minnesota. Didn't bother me. We weren't the ones registering, but we definitely have an obligation to make sure that we provide as a resource for our persons under supervision to get whatever they need, not just in resources, but also to have a voice in their state and their democratic process. So we also have hosted multiple small workforce career fairs in our Workforce Development Center. Again, we've used Second Chance funds to help with rent payments, for those that may be struggling with respect to housing needs, any kind of educational programming needs. I won't go into our reentry court program, but we do have a reentry court program in Eastern Louisiana. When I was chief, I've actually created 2 reentry court programs, one on the front end and one on the back end. With the good work and the assistance, I should say, by former U.S. Attorney of Eastern District of Louisiana and former Deputy Attorney General of the Major Crimes Division, Ken Polite, for DOJ, we created a reentry program on the front end after observing Judge Gleason's program, went to Central Illinois, observed their program, but we wanted ours to be a little bit unique. And one of the things through Ken's assistance, he offered, it was definitely a straightforward, like a diversionary type program, because the carrot was not, have a year off your sentence or a time served sentence. The carrot was a dismissal. And he honored that dismissal of the charges. So I hope I wrap it up there.
Thank you so much. Thanks, Chief. Last but not least, I'm turning to Yossi. Yossi, I've watched your unwavering commitment to individuals you work with over many years, and I know how passionate you are about people having someone standing by them who cares. Can you please talk a little bit more about why you think this is important for all people facing criminal prosecution?
Sure. Thank you, Hanna.
Thanks.
Chief, you mentioned that we need to tell the story, and we try very hard to change the story right before the story is told. And for us, it's mentorship. There's no reason to wait until a person is already standing before the judge at sentencing. When people call me and they say, my sentencing's coming up in 2 months, I'm like, you should have called me earlier. I try to put the word out. Call me as soon as you plead, as soon as you're indicted. One of my colleagues asked me, when do you want these people to call you? I said, before they commit the crime. That would be best. I work with a team, so obviously this is not just me. It takes an army to help somebody over a period of a few months, sometimes a few years, to get them to grow quickly before sentencing. A judge ought to know the backstory, so we put together a mitigation narrative. A judge, a probation officer ought to know a lot more about the individual, psych eval is done, and all those, I believe, all those things assist in giving a clear picture, not just for those individuals, but for us. We have to come up with a plan to help these people before they face the court. So once we know everything that's going on in their kishkis, a Yiddish word for really knowing everything that's going, identifying the underlying issues, and then addressing them. We're there not just as a friend to help them navigate the criminal justice system and come up with tricks about how to get around the problems that they're in, but rather we tell them that your remorse, which is something that it takes a lot of time. People come to weekly classes that I offer and various other ways that we can engage them to understand that there needs to be an acknowledgement of an offense. When someone calls me and they say, I'm really innocent, but I'm not going to go to trial. I mean, I had to plead. I tell them, look, I can't help you. You need a good lawyer. I can help people who are guilty and they're acknowledging that they did something wrong, and I'm very inspired by people who want to turn their lives around. Now, the complaint I get mostly from attorneys is that it looks contrived. It looks like, it doesn't look good for the judge that this person just started to get their life together and they're just figuring things out now, and even though it's been many, many months and sometimes years. And, that bugs me because if there ever was a time, that something should be contrived, I hope it does look contrived. I hope that the judge sees that ultimately I'm trying to come up with something that can help them. And I believe even if someone doesn't come to our organization at the Aleph Institute, it's still a very good idea for a defense attorney and they can be encouraged to do so, to find somebody, to identify someone who can be a mentor. It could be a family member. They're going to end up getting 50 letters, 100 letters. Can one of those people perhaps step up at a time like this and help this person come back to their mission? I truly believe every person, 7 billion people in this world, have a very specific mission that's unique to them. And all we need to do is get them back on track, and they will be able to be trusted to stay out of trouble. When they're engaged in why they came here, to bring positivity and light to the world, they'll be okay. So I kept hearing that complaint from attorneys about, the work that we do being contrived, and I decided it's time to review what that word actually means and figure out, what am I missing something here? And of course, it says deliberately created rather than arising naturally or spontaneously. And that's exactly what we're trying to do. We want to deliberately create and craft a plan that hopefully the judge will be impressed by. There was the late Judge Wexler in the Eastern District. He passed away a few years ago, but he was very inspiring to me. He would defer the sentencing, sometimes for years. And the idea here is not to say, like so many attorneys tell their clients, stay out of trouble. All you got to do is stay out of trouble, let me do the rest. No. Staying out of trouble is just the beginning. Obviously, it's all about doing extra, doing more. There was damage done to society. You need to figure out how to bring something there, bring something to the table, bring something to the court that you could talk about, or I could talk about on your behalf, and ultimately be able to advocate for an alternative to incarceration that includes a continuation of those programs, and we're asking the judge not to interrupt this important process.
Thank you. On that point, I'd like to turn back to Judge Friedman, because you talked about, and you wanted to talk more about the relationships that you can build, and like Yossi was talking about, can you talk about how you can really bring that to life?
Sure. Can you hear me? Yes. Great. So just to talk about a couple of things that I heard and that I really support. To go back to what Judge Bennett said about visiting facilities. So I didn't specifically go to facilities to visit individuals that I incarcerated. However, I did make sure, and I encourage every single judge to make sure that they visit any facility that someone that they sentence will go to, jail or prison. And I think it's really, really important. When we so easily say out of our mouths, 30-day postponement, we need to understand what a 30-day postponement actually looks like for that individual and where they're going back to for those 30 days. Really important. Delayed disposition. So that's a strategy that I used as well a lot. Basically, what I would do is I would take a plea, on a given day, because we know how important it is to get the case off the docket. It's about the numbers. And that's another issue that I have with the whole thing. But so that would take the case off the docket officially if there was a plea in that case. But then as you interact with the individual and really find out what the underlying issue is, basically give them the time to do that program. So whether it was, let's say they needed substance use help, send them rather to a program, reset the case for 90 days or whatever the time period is, see if they would be able to, if they were able to do that program and successfully complete it. When they would take their plea, they would know what their minimum would be if they completed the program, what their maximum would be if they did not. And really, it empowered them to really decide what their future looked like. And I think that's really powerful. As far as creating the relationship, what I did and what I really encourage my colleagues on the state, I'm not talking to federal judges, whole different ballgame, but my state colleagues to do is I would have regular status hearings with all my probationers. So what that meant was for most judges, they sentence someone, they put you on probation, and then they don't see you again until you violated or did something, whether technical or a new arrest, and they have no relationship with this person. I saw you a year ago, 6 months ago, whatever it is, no relationship. But what I would do rather is create the relationship by seeing the individual, not everybody, because everyone doesn't need this, and you have to know your high risk, high need, and all of that, but the people who needed that, who had specific underlying issues that I had ordered them to do substance use, mental health, vocational training, whatever it is, and follow their progress, whether it's monthly or every other month, to create that relationship and to also make sure that there was a proper fit. Not every program is for everybody. And the beauty of having gone into the community, I really was able to identify different programs. So if program A didn't work, could be personality, could be neighborhood. There are many, many reasons why programs don't work for individuals, but have the resource to be able to say, okay, this didn't work, after I saw him 30 days later, relationship's not going well, all right, let's try this. And it gave me the flexibility to change, where this individual would be going and create that relationship. And not only is it important to create a relationship with your probationers, it's important to create a relationship and trust with the state and the defense. The only reason why I was able to do this is because they trusted me. The defense knew that I was really focused on helping their clients, but at the end of the day, the state knew that if he didn't do what he was supposed to do, at some point, it might not be the first time, it might not be the second time, but at some point, the individual was going to go to prison. I wasn't scared to send people to prison. I wasn't adverse to sending people to prison. I just didn't want prison to be option number one. But if I tried everything else, then the state knew at some point that this individual had to go to prison. And I was able to sleep at night because I knew that I gave that individual every opportunity to help themselves. And what I would always say is, I can't care about you more than you care about you. And the day you show me that I care more, that's the day that we have to change what I'm doing here. And so that trust was really, really essential to allow me to do what I did.
Thank you so much. I have so many other follow-up questions and would love to extend the conversation, but I just got the signal that we're 10 minutes out, so I would like to open it up for a few questions. So are there any questions? Do we have...
Touch point in the system, particularly in the state side, but also in the federal system, and how that impacts your work. Fees for diversion programs, fees you have to impose at sentencing, fees that tether the person to the system for a very long time. Minnesota used to suspend driver's licenses for people who didn't pay their court findings and fees, so getting them that CDL might not work for everybody if they had experience in that system. What do you all do, I hope, or think about when you think about the money in the system?
Who wants to take it?
So I can be real quick from a federal side because we don't really do a lot of collection. We have special assessments and we have restitution. It's very rare. In my 20-something years, I rarely have seen a fine issued. So what I will say, though, is, we do collect the special assessments for the most part. That's have not been a big issues for us. And I've been in 4 different districts. But we also use Second Chance Act monies that we are funded to help with providing some of those barriers and address some of those barriers that exist. So if somebody does have some kind of driver's license issue, and again, I'm talking from a federal level here, or some issue whatsoever, as long as it's within our regulations and it's not prohibited, then we have used Second Chance Act funds. I have signed off personally on using Second Chance Act funds to help address some of those things that are situated with the driver's license, restoring somebody's driver's license, again, rent payments that they may be, if they need a deposit to get, an apartment or something, staying at a hotel because they have no other place to go and there's no other way to, make payments, no family contributions and whatnot. So we have used Second Chance Act money to assist in that vein. And then the final thing I would say on this is that, from the federal level, if every now and then we'll have folks that are responsible for co-payments for treatment services, whether it's mental health, substance abuse, or even location monitoring. But if they can't pay, then that does not prohibit us from still paying the invoice in full. So we, from the federal level, we tend to address all of that.
From the state level, fines are not common, so I never really had to do with fines. Fees, to be frank, anyone who ever asked me to waive a fee, I waived fees pretty much regularly. It's Baltimore City. They have to prove indigency. It's not that tough. So that wasn't really an issue. Restitution was a different issue because obviously I wanted to get the victims made whole. So what I generally did was held their hand through that process. My experience, and no offense, and I told the chief I don't mean to offend any probation officers that are here, but my experience with the probation system was, first of all, I had a lot of victims contacting my office that they weren't getting the money. I would have guys telling me we sent the money in, they have to send it in these special envelopes that somehow never make it to probation. And it just got to the point where I decided that my office would handle it themselves. And I would have, in my status visits with my probationers, I would have them bring a check-in for the victim, or usually a money order that they get at like 7-Eleven. I would break down the payments for them to make it manageable on a monthly basis. I felt like also most of the defendants that came in front of me weren't really good with managing payments or really doing it on their own. So having me kind of holding their hand and being a cheerleader through it and making sure it was done was beneficial to them and frankly the victim, because then my office would directly send the money order to the victim and I would keep an accounting of it. And this way I would make sure before I took someone off probation that the victim was made whole. And sometimes what I would do if at the end of the probation period it wasn't, I I would change it from supervised to unsupervised probation, so they didn't have to do all the, restrictive things of a supervised probation, but at least I could extend the time that they had to make that restitution in full.
If you have anything to add.
Oh, sure. Just a couple of things. Broward's Mental Health Court was the model for the Law Enforcement Mental Health Project legislation that was spurred by Governor DeWine when he was a senator, as well as Governor Strickland when he was a U.S. representative. And that seeded other diversionary mental health courts throughout the United States. We don't get any money. We get no grants. It's really, I think, going back to we didn't really talk about it, but really focused on the power of collaboration. That task force that I mentioned met for years. And, I remember as I was serving as on the President's New Freedom Commission under President Bush, we had a private dinner meeting with Mrs. Carter, and she talked about the power and the importance, of building these networks, of really, working collaboratively and getting to know the people that you're working with. And it really was through this collaboration that community agencies across the entire county were willing to basically break down their service model and actually support the court, which was almost unheard of. But that was really, I think, that power of collaboration, and more to the point, giving great credit, I think, to our community partners and stakeholders that had an immense thirst for justice. Thank you.
Great. We do have a time's up, but I'm going to take one more question because we have a few minutes until the last panel at 3 o'clock, which is going to be fantastic, and then a very important live Zoom session while you're getting the microphone. I was just going to say that.
Is this
Yes.
on?
Thanks,
I have a question for Chief Best. I'm Liz Oyer. I work for the Justice Department now, but I spent 10 years as a federal public defender. And I really liked what you said about your model of supervision and support on reentry. I will say that in my experience, probably the majority of my clients would have said that their relationship with their probation officer was neutral at best and adversarial at worst. There was not a feeling that the probation officer was a partner or a support or a trusted person who was accountable for their success in the community. So I guess I just want to ask you, how do you get your probation officers to buy into that way of thinking of like sort of some shared accountability for the success of individuals who are returning to the community?
Okay. So, funny you asked that, because I have strong strong views on the word buy-in at times. So it is very difficult because you do have people that have very strong views on how things should be done. So what I would say is I tackle it two ways. One, I still have a responsibility as chief to put the vision out there and provide the training and whatever resources that we need to help be a positive influence to hopefully get people to buy into the message, correct? But the second thing is I think you also have to achieve it through your hiring process. So as chief, I don't just bring in people who just have a probation officer background. I diversify the palette, and my supervisors know I don't have any problem whatsoever being the lone person to say, nope, this is the person that I want. Everybody else disagrees with. We're going to move forward with this person here. Sometimes you have to lead with courage, whether people are going to agree with you or disagree with you. I bring in folks that have backgrounds in treatment services, mental health, substance abuse, people who have demonstrated. I don't just look at and read a resume and somebody tell me what they're knowledgeable of. I want to know what you actually have done, demonstrated skill sets. And when we're doing the reference checks, that's what I'm asking for. Not that they have knowledge. What have they actually done? Demonstrated the skill sets and evidence-based practices. Demonstrated the skill sets sets in workforce development, reentry initiatives, demonstrated the skill sets with mental health or substance abuse as counselors, as case managers, what have you. I just hired and started just 2 weeks ago a former high school guidance counselor. You know, our reservations are having some issues with a lot of youthful offenders in our northern territory of Minnesota. Not many of us have a long background of dealing with youthful offenders. So, you know what? Think outside the box. Here we have someone who has a licensed state as a guidance counselor that has history dealing with youth, so therefore we can teach them the legal terminology, but they can definitely work with the youth themselves because they have that background doing it. So to me, you have to, the way around that, sometimes, you know, the good news is in the federal system, you can age out at 57, and then folks can retire when they want to retire. And then we can replenish our staff. And this is not a knock against our staff, but this is a system. It's how it is. So therefore, we take advantage of it as chiefs. So for me, I take advantage of it by diversifying the palette, bringing in people from multiple disciplines, multiple industries that have a demonstrated background, not just knowledge, but a demonstrated background in working with folks. And to me, that's how we get it done.
Thank you so much. Thank you so much for attending this session on innovative practices in sentencing. If any of you are half as inspired as I am, we're going to have justice-enhancing practices in every jurisdiction by next year. So, yeah. Anyway, please join us for these follow-on.
3 o'clock, we resume in the first floor theater. 3 o'clock in the theater, first floor.